Application process. Because E-2 approval is reliant on the development of a business, the entire process requires complex calculations, market research, and advanced planning. As such, interested parties are encouraged to consult with legal counsel and advisors as early in the process as possible. Interested investors can petition for E-2 classification through Form I-129 to change their status from another legal classification if already in the United States, or by filling Form I-29 from outside of the United States. Terms and conditions of E-2 status. A treaty investor or employee may only work in the activity for which he or she was approved at the time the classification was granted. An E-2 employee, however, may also work for the treaty's organization's parent company or one of its subsidiaries as long as the relationship between the organizations is established, subsidiary employment requires executive, supervisory, or essential skills, and terms and conditions of employment have not otherwise changed. USCIS must approve any substantive change in the terms or conditions of E-2 status. A substantive change is defined as a fundamental change in the employer's basic characteristics that would affect the alien's eligibility for E-classification, such as, but not limited to, a merger, an acquisition, sale of the division where the alien employee is employed, or other event that affects the treaty investor or employee's previously approved relationship with the treaty enterprise. Where there has been such a substantive change, the treaty investor or enterprise, if it wishes to continue to employ the alien in E-2 status, must notify USCIS by filing a new Form I-129 with fee and may simultaneously request an extension of stay for the treaty investor or affected employee. The Form I-129 must include evidence to show that the treaty investor or affected employee continues to qualify for E-2 classification. An employer who no longer employs an E-2 non-immigrant is urged to inform USCIS of this upon termination of the E-2 non-immigrant's employment. A treaty investor is not required to file a new Form I-129 to notify USCIS about non-substantive changes. Period of stay. Qualified treaty investors and employees will be allowed a maximum initial stay of 2 years. Requests for extension of stay in or changes of status to E-2 classification may be granted in increments of up to 2 years each. There is no limit to the number of extensions an E-2 non-immigrant may be granted. All E-2 non-immigrants, however, must maintain an intention to depart to the United States when their status expires or is terminated. An E-2 non-immigrant who travels abroad may generally be granted, if determined admissible by a U.S. Customs and Border Patrol officer, an automatic 2-year period of readmission when returning to the United States. The E-2 visa is a great option that allows the holder to live and work in the United States by investing in a U.S. company, but it does not directly lead to a green card. In order to go from an E-2 visa to green card, holders must apply for and get approved for an immigrant classification. Some of the immigrant visa classifications that should be considered are the EB-5 visa, a company sponsorship, EB-1A, national interest waiver, and a marriage-based green card. Converting an E-2 visa to an EB-5 visa is one of the most straightforward and natural ways to go from an E-2 visa to green card. Join our next videos for more information.